Hi everyone, I'm David Fixler. I'm a partner in the IP team at Cause, and we're very happy to be hosting this AIPPI event. Before inviting Claire Cunliffe up to introduce Dan, I'd just like to acknowledge the Wurundjeri people of the Kulin Nation, who are the traditional owners of this land, and pay my respects to their elders, past, present and emerging. Claire, without anything further, please introduce Dan.
Good evening, everybody. I'm Claire Cunliffe, the Treasurer of AIPPI, and it's my very great pleasure to introduce Dan Hunter, the Foundation Dean of Swinburne Law School. Professor Dan Hunter is an international expert in internet law, intellectual property and cognitive science models of law. He's very highly qualified. He has a PhD from Cambridge on the nature of legal reasoning, as well as computer science and law degrees from Monash University and Masters of Law by Research from the University of Melbourne. He's taught at QUT, the University of Melbourne, Wharton, at the University of Pennsylvania, Cambridge, Deakin, and New York Law School. Professor Hunter has a number of publications, most recently the Oxford Introduction to US Law, Intellectual Property, Amateur Media, and 2 books on gamification. I'll leave it to Professor Hunter to explain to you what gamification is. His work is focused particularly on cultural histories of intellectual property in the post-war period, and he's worked on the history of Lego bricks, modernist furniture, Barbie dolls, and the social significance of luxury handbags. Tonight, Professor Hunter will be addressing us on the history of Barbie, and I'm sure you'll have questions, but if I can ask you to leave them till the end. Thank you.
Thanks very much, Claire, and to AIPPI, which I've been told never to pronounce as AIPPI. Apparently it's disrespectful, and to Cause for hosting this. So thank you very much, and actually to all of you for coming out tonight. It's always a nice thing to have an actual audience. Normally I expect no one's going to turn up. In an email thread that got forwarded through to me from a friend, perhaps it was at Cause or Ashurst, I'm not quite sure. I read down a little bit, like because they always get repeated, or the previous one gets stuck underneath, and so in the thread down there it was like, oh, you should go to this. Dan Hunter is usually entertaining. I was like, usually? Jesus, all right. So hence the wine, because I'm trying to deal with that particular thing here. So yeah, as Claire said, I do work in cultural histories of intellectual property objects. And I also do actually, these days, I spend a lot of time thinking about the future of law and about artificial intelligence, and occasionally do some stuff on blockchain, but I try to avoid that. But today we're going to be focused upon intellectual property objects, specifically Barbie. The reason for this, or at least sort of, I guess in a sense, the high point in all of this, the end point is this. Unfortunately, it's been cropped off a little bit, but I encourage you all to go to Amazon and type in a history of IP and 50 objects, and buy $34.95. It's an excellent coffee table book. It comes out next month. But this talk is in part one of the starting points, one of the foundations for this thing, which became this book. We've got 50 authors from around the world who have looked at intellectual property through the lens of objects. Many of you will have seen the history of the world in 100 objects, or the one that I love is that was the first one, right? That was the British Museum, the Smithsonian in America, and I can say this because I'm an American citizen as well, and I'm married to an American. But the Smithsonian decided to do the history of America, and they decided to 101 objects, right? So 100 objects for the world, 101 objects for America. That makes perfect sense. But we decided, 50 objects, because we didn't want to just have photos. We wanted to have stories that were told. So each one of the entries is about 1,500 words, and written in a kind of a really enjoyable style by a range of people from Harvard and Cambridge, as well as from firms and we've got sociologists and all sorts of people. And this story that I'm going to talk to today around Barbie is part of that whole discussion. And the idea behind this, as I started to think about this, both this book and all of these cultural histories is how do you tell the story about intellectual property, right? So for a long time, having been an intellectual property lawyer, you go to cocktail parties and you are 100% the most boring person there because, you sort of say, oh, well, well, intellectual property really matters. And they say, well, why? And you go, well, it's absolutely fundamental to the life that you live right now. And they go, well, how? And you go, well, the Wi-Fi router. And they go, well, that's not really intellectual property. You go, no, really, it is, right? It was invented, it was an invention of the CSIRO, right? There's hundreds of millions of dollars which has flown back to the CSIRO as a consequence of an invention that came about through astrophysics. Right, they were trying to do communications, and they said it wasn't possible to actually cram that amount of communication into the bandwidth that was available. And the guys at CSIRO said, no, it is, and we can stick it on a chip. And then, got into literally a $500 million patent fight in the Eastern District of Texas over whether or not Cisco and others and Apple and so on had to license that technology because it was patented here in Australia. And they go, well, it's not that interesting. And you go, well, what about the contraceptive pill? Right, I had the reason that I was at Cambridge was I had a Herschel Smith Fellowship, and Herschel Smith was the guy who created the steroid that actually enabled the contraceptive pill to be created, and as a result changed women's lives dramatically, but also mine, because he endowed the fellowship. And they go, well, that's your story, Dan. That's not that interesting. I said, what about Lego? Right, this is an absolutely fascinating story, and so I got into the whole Lego thing. I've actually given a talk about Lego at AIPPI again, so I won't reprise that or reheat it for you. But as I was sort of looking at all of these things, whether it was Lego, whether it was Barbie, whether it was modernist furniture, which I wrote about as well, which is a fascinating story about, well, what does it really mean to have an authentic piece of Eames furniture? What does it really mean to have the Hans Wegner chair, right? The one that everyone really loves, and unless you're a modernist furniture nerd like me, you wouldn't really be interested in that. But it's just like, these things really matter a great deal. People say that these things, really are important to our lives, and I'm like, okay, how do you tell that story? How do you say that intellectual property really, really matters, as opposed to just okay, we have to do it for our professional lives. You're advising clients, you're making a reasonable amount of money out of it, I hope. How do you actually tell these stories at dinner parties? And so I sat down and started to write out these sort of what we think of as cultural histories, but it's also a material culture history. And this is something which, unless you happen to be a humanities and arts sort of geek, you're not going to go, material culture, what does that mean? But it's a really simple observation. One of the best ways of understanding a society is to say, what are the things that we produce, right? Because the things that we produce and the things that we use matter a lot, right? Why is it that the chairs look a certain way? Why is it that Barbie is the way that she is? Why is it that the Lego brick is always in your kid's bedroom and you step on it in the middle of the night while you're putting them to bed? You're like, how did these things come about? And they came about through intellectual property. And if you start looking at those histories, it's a much more interesting cultural history and a history of these objects that actually you can go to dinner parties and like Kelly, who's in the audience here somewhere, right, with a number 3 Barbie, which I hope that you will all take the opportunity to go and take a look at, right, to say these things actually really matter, and they came about because of the stuff that professionally that we do. So it turns out that we're actually much more interesting than we thought about. As for luxury handbags, that was just because it was a good excuse to meet women back when I was single, so we won't talk about that. My wife's not in the audience, thank God. Okay, so how do we understand societies? By the things that they produce. So this talk is not going to really reference intellectual property law that much, although there's a lot of that kind of stuff in there. And it's really a case study around the development of the intellectual property system internationally. Although that story actually is probably better told around Lego. And if you ask me about Lego, I'll bore your brains out. So don't ask me about that. So Lego is really interesting around the way that this tiny company in this tiny place called Billund, Denmark, managed to become this enormous organization that sort of spans the globe through intellectual property. The story about Barbie is somewhat similar. And there are 2 things that are sort of at the core of Barbie. One is the demonstration, and this is a somewhat controversial point in this room, but it's a really important point to note, which is to say that trademark is the only really interesting part of intellectual property. I know that's, like, we can fight about that later, but trademark is really where it's at. And that's actually a really interesting story when I talk to my students, because they kind of go, oh, copyright, that's really fascinating. Or patent, I can make a lot of money. I was like, no, trademark is the thing that drives modern capitalist society. And Barbie is a fantastic lesson in that, although all other parts of intellectual property are implicated and involved, right? So we'll talk a little bit about that. But actually, this is the really tricky and fascinating thing when I started to look at Barbie, which is at the heart of it, there is this amazing intellectual property detective story. Right? Why did Mattel screw up so often and so consistently in their intellectual property strategy? Right? Like, because I was looking at it, and so Jill Barad, who was the high-profile CEO of Mattel for years and years in the 1990s, her comment was her only job was to protect Barbie. Mattel had lots of other properties, but her job was to protect Barbie, right? And I was like, okay, so why are you doing such a bad job at this, Jill, right? And the answer is, and this is of course the best answer in any detective novel, why did the murderer commit the murder that he or she committed? Why did the criminal create the crime? And the answer is, of course, sex, right? So at the core of the Barbie intellectual property story is a detective story about sex and the inability of Mattel to get past the initial dubious history of Barbie to get to the point where they could go, you know what, we actually need to be clever about our intellectual property strategy, particularly our litigation strategy. And they kept stepping on their own toes all the way through the 90s into the 2000s. And that's really the story, and I'll talk a little bit about that. I'm going to leave plenty of time for Q&A, because the Q&A, I'm sure, is much more interesting, particularly when Kelly gets to show her Barbie number 3. Okay. All right. So this whole thing, this whole talk is really just about this question about how do firm innovations connect to intellectual property laws and connect to innovation policy generally, right? So it's not just about the laws, it's about what do firms do, what do companies do when they're confronted with the intellectual property system, and how do they actually play around with it? What do they do with it, specifically in relation to sex? So Barbie is, of course, in the old I think Matthew, the Word made flesh, right? So our God is the Word made flesh, and she is the Word made flesh-toned. She is the Venus of California. She was created, or first came onto the scene at the New York Toy Fair in 1959. So she's 60 years old, and she's looking great, all right, for an old thing. The 3 things I'm going to talk about are her dubious history, which many of you will know, right? How many people here know her dubious history, or the so-called dubious history, that Barbie is actually a hooker? Okay, well, we'll talk about that, but that's actually not the dubious history. The dubious history, the reality is that Barbie actually is a knockoff, right? That's the amusing thing. In the intellectual property dubious history, she's a knockoff. It's not that she was a call girl. We'll then talk about how Mattel developed its intellectual property strategy, but it just sort of couldn't get out of its own way when sex emerged. Okay, so the dubious history is this, right? So hopefully you can kind of see it. It's not all done all that well. So on the the left-hand side, you see some of these cartoons, and this is from a post-war German newspaper called Bild Zeitung. And this is the artist for this was Bethien, and he created this character called Lily. And she was something which we saw weirdly enough in the Audrey Hepburn character in Breakfast at Tiffany, right? Which wasn't really referenced at that time. It's also in Butterfield 8, the early Elizabeth Taylor, where you had a woman who was basically, she had a lot of boyfriends who would give her $50 to go to the ladies' room. I don't know if you remember this sort of thing. It's all sort of like whitewashed in Breakfast at Tiffany's. But she was a girl who was basically hooking on the side, right? And that was the Lily character. She had lots and lots of older boyfriends. She was always scantily clad, and she was always accepting money for doing things which are never really specifically talked about, but referenced, right? So that's the Lily character. So for reasons that nobody's ever been really able to clearly identify, there was a doll manufacturer called O.M. Hausner who created these Lily dolls that you see there in the middle of the screen. And these Lily dolls were really unusual for dolls during that period, indeed really unusual for dolls up until fairly recently, because dolls were usually babies. Right? In the really early period of doll manufacture, they're actually used as fashion maquettes, where you would actually, the way in which women would order clothes from I would say designers, they didn't exist, from seamstresses and fashion houses, was to actually look at the dolls. So that was the earliest period of the dolls in the 17th and 18th century. You can tell I actually learned a hell of a lot about really weird things in researching this work for this article. So they had those things, but then very quickly most dolls became representations of children, babies, in which we're really familiar with, and were no dolls of women, right, or indeed of men, and so Lily, the character is usually called Bild Lily because the newspaper was called Bild Zeitung. So Bild Lily was this unusual doll that was created in the mid 1950s, early to mid 1950s, by this German company called Hausner, and she was a strange thing. She was sort of found in sex stores, and guys would buy them for their girlfriends. They would often be found in things like on the dashboard of long haul truckers and the like, right? These were adult dolls, right? In that sort of like in the sense of sort of kind of being a sex toy. The Bild Lily is often called in the literature, particularly with American writers, as a sex toy, which is like, that's a pretty weird definition, but we sort of get the point, right? It was a sexualized toy. It wasn't something which was for kids. And so Ruth Handler, who was the vice president for marketing and clearly the genius behind Mattel, right? So there was Matthew something and Elliot Handler, who were the two founders, and that was a plastics company, and that was what's called Mattel, Matt and Elliot, right? Mattel. But Elliot Handler and Ruth was his wife, and Ruth was a marketing genius. And so she was working at Mattel doing all of these things where they were creating, originally they were sort of creating plastic resin tables and chairs and things, and then they sort of moved into toys. They had some things like guns that sounded like machine guns and the like. And she took her kids away for a holiday in Switzerland. Her children, she had a girl and a boy. Anyone know what the names of the children were? Come on. Ken and Barbara. Absolutely, I'm not shitting you, right? It's like, wow, okay, that's a little weird, right? But she took her kids, Barbara and Ken, away for a family vacation in Switzerland. In the mid to late 50s, I think it was like 1957, 58, that she took them there. And in a toy store, they think it's in Luzern, but it's not clear. It could have been in Interlaken. She found these dolls, and she bought 3 of them, and she took them back to the States. And she said, this is going to be the next big thing that Mattel creates. And so she then didn't sort of ignore the whole kind of call girl aspect of Bild Lily. But the thing that really matters for us as intellectual property lawyers is the fact that as you can see here, if you have a look at Kelly's doll, I strongly encourage it. It's number 3. It was still made in 1959, which is the first year it was released, right? So there were those 3 versions of it, because there were lots of editions. This was the first version of Barbie. Okay, it was created in Japan. It was the only place that could do the plastics properly. But as you can see, with the exception of the crown here and the nature of the hair, this is 100% just a knockoff, right? And we know that because what she did was she sent 2 of the Lily dolls to Japan to get the dyes manufactured directly from the Lily dolls. right? So like Lego, and I hate to break your bubble, but if you haven't heard my talk about Lego, right, it's the same story. Lego is 100% a rip-off of the automatic binding blocks that was created by an English child psychologist called Hilary Page. They just ripped it off, right? No question. She did exactly the same thing. So the dubious history, the amazing sort of fascinating thing, there's Ruth Handler there somewhat later, and there's the early, I was going to say Lily, but it's actually the, I believe it's actually a somewhat later Barbie. I can never tell the difference. It's the dubious history, is the dubious intellectual property history, is that she's a knockoff. Right, and so the really fascinating thing is that conceived in sin, not in sex, but conceived in an intellectual property infringement, the moment from that period on, or the thing that happened from that period on, is that Mattel realized the significance of intellectual property, right? And for a long time, up until in fact the time that Mattel went to the 1959 New York toy show, Mattel refused to show their toys at those things because they were afraid of knockoffs. And yet they did exactly that, right? So it was this very competitive world at that time. It was fantastic. If you ever get your hands on an early G.I. Joe, that was created a little bit later by a different company, you will see two things, right? One is a scar on his face, and when asked why did they put a scar on there, they said, oh, we can trademark the scar. Like, well, that's not quite right in intellectual property, but they could say that anyone who came along and knocked it off, if there was a scar there, that in fact it was a knockoff. But in fact, the better thing that was the more amusing kind of story out of all of that was that because of a manufacturing defect, the early G.I. Joe had the thumbnail backwards on the right-hand thumb. And at first they were really ticked off about that. And then they were like, great, because it means that anyone who knocks it off, we've got the evidence right there, right? If the thumbnail is backwards on the right hand, then it means that they've ripped it off directly from us. So the fascinating thing about Barbie to start with is that she's a knockoff. And she's a knockoff based upon this somewhat unusual character called Built Lily. So from that initial dubious past, you then had a series of things that Mattel did that were absolutely consistent with the way in which you would advise any of your clients, right? So what they did was they then went on an absolute rampage in the appropriate way, right? In the appropriate intellectual property strategy way of getting as much intellectual property as possible. Okay, so copyright's kind of out of the question, right? As you all know, like doesn't really apply to these sorts of things very well. But in patents and trademarks, they were absolutely ruthless, and so they patented far more than anyone else. Jack Ryan, who sometimes is credited as the father of Barbie, but really wasn't. He was an ex rocket scientist. Married Zsa Zsa Gabor, amusingly enough, that he was her sixth husband. Those were the glory days. He patented the way in which she was standing, like the way in which you could actually move around, various maquettes for this. So there was a very large sort of patent portfolio that was generated. There was also a very large trademark, and these days obviously a domain name portfolio that Mattel were really, really serious about prosecuting. I put in the article, and I'm happy to give you a copy of a reprint of the article if anyone's interested at the end. I put in the article that in fact the Barbie pink is trademarked. And when I went out to find the trademark registration for Barbie pink, the color pink, for Barbie, I was chastened to discover earlier this week, in preparation for this presentation, that in fact Mattel abandoned that trademark registration in the United States. So there might be a Barbie pink registered in some country, but I don't know what it is. So I regret to say that Barbie pink is not a trademark, but Malibu Barbie, Barbie Princess, Barbie, like there's just an enormous number of trademark registrations for Barbie in the US test system. I actually got there. I think I've got, it's the one that I put up there is number one of how many? 301 trademark registrations within the US system alone, and similar numbers in other places. So you get the idea. And obviously a similar number of, or not similar number, but a large number of domain names as well. And so Mattel has really been very, very careful about its intellectual property prosecution strategy. Okay. Now the thing about Barbie, and this is the thing that actually interested me most about Barbie as an intellectual property object, right? So I guess there were two things. and they're interrelated. If you think about most intellectual property of that period, or most objects that embody intellectual property, the intellectual property strategy wasn't very clearly formed, right? Like, a lot of companies took a hell of a long time to actually work out what to do with intellectual property. And Mattel is really unusual that from the jump, from day one, they were absolutely all on top of intellectual property. They knew exactly what they were doing. So the marketing department, in conjunction with the General Counsel's office, were really, really clear about its intellectual property strategy, including its intellectual property strategy as a licensee of Barbie. So if you look at Lego as a counterpoint, another, so Mattel and Lego are the two largest toy companies in the world. I think these days still, certainly a couple of years ago they were. Lego didn't license out or license in any of its intellectual property until 1992, right? So the first time that Lego licensed in any intellectual property was the Star Wars box, a Star Wars theme that they did, right? 1992, that's incredibly late. Mattel was doing it from the 1960s, right? From really, really early on. They had Barbie cartoons, they had Barbie everything, even though they weren't producing it. Barbie, bed sheets, Barbie towels, Barbie, you name it, right? Even though they weren't producing it as toys. And so the way in which they did that, of course, was to have a really clear intellectual property strategy. When you think of Barbie, you associate it with Mattel, you know exactly what it is. Her IP identity is as clear and distinct as a struck bell. There's no fuzziness about it whatsoever. That requires a huge commitment early on. I imagine that if you think about some of your clients, you're like, wow, I wish they were quite as kind of on it as Mattel, right? There are very few companies that have been as on it as that. At the same time, of course, Barbie is this lightning rod for visions of femininity and concerns about ways in which women are represented, right? And there's lots and lots of literature around this. There are feminist, clearly feminist, and other just sort of more general sociological and anthropological literature around the sorts of problems that Barbie creates. And any attempt by the company to sort of get around that kind of doesn't work. The two examples that I've got there, you'll see some of the images of the heads of Barbie from 1968 through to 76. So in 71, I think it is, yeah, you'll see. So the difference here, 1970 to 71, her gaze goes from being this kind of demure sideways gaze to a front-on direct gaze, right? And the company heralded that as, wow, look at how much we've improved our at the persona, right? Much less submissive, much less problematic. I'm like, yeah, okay, guys, great. This particular vision down there is the difference. If you take a look at Kelly's number 3 from 1959, you will see that Barbie has to be in high heels. Right, that the shoes or the model of the doll it absolutely has to have high heels, as you see off there in the left-hand image in the blue jeans, and then in the late 1990s, early 2000s, I can't remember exactly when, she started wearing flats, and to this day wears flats. Right, so any attempt by the company to sort of deal with these concerns, they're half attempts. They never quite work. So then the company, in dealing with these sorts of problems, starts to run into some issues in the connection between their intellectual property strategy, which was great, they were killing it, and the way in which people start to use and misuse Barbie, right? And this is where this detective story starts to come out and where I got really interested in what was going on, right? So you started to see people appropriating Barbie for various purposes, which is, what you expect these days, right? Appropriation and remix. These days we kind of go, that's great. But this was fairly early on. Barbie is a pretty unusual cultural object. These two images that you see here are images that, generally speaking, you would never actually see. Todd Haynes, who actually is these days a really well-known director, working with Dollhouse, a range of others, used Barbie to create Superstar, which was a retelling of the Karen Carpenter Death by Anorexia story, where he shaved down the limbs of Barbie, right, and created a whole stop-motion picture that was using Barbie, but using Barbie as Karen Carpenter and showing her struggles and eventual death. Mattel was so outraged by this particular use that they threatened suit, and eventually the distributor dropped it. So we had to go to we actually had to go to Todd Haynes in order to get these particular images because they're not otherwise available. So this was I won't say the first, but one of a number of times when the company started to have to deal with, well, what are we okay with when people use Barbie? Because people are going to use Barbie. It's just like, what are we all right with? And it's really sort of interesting. So Barbie being used as a puppet in recreations of various art exhibits, sort of the girl with a pearl earring, the Shriek, that's a Frida Kahlo down there. I've forgotten I think it's not a Degas, it's a Manet. Yeah, thank you. And so all of these versions, right, of famous paintings and other things, the company kind of went, all right, we're sort of okay with it. We'll let it get through, in large part because, of course, within the American system, fair use does grant a pretty serious level of protection. And then Tom Forsyth came along with what these days we call Barbie in a blender, but actually he called food chain Barbie, where he took Barbie and the intersection between Barbie and sex and food preparation objects was just too much for Mattel. Okay, so he created this food chain Barbie series in 1999. Made a grand total of $3,659 out of this particular series. Word has it, although I couldn't get this confirmed, but I'm pretty sure this is true, that the vast majority of the money that he made as a consequence of purchases by Barbie's lawyers in order to bring the action against food chain Barbie, which we're here, right? You can see obviously there in the top right hand. It's sexualized, but it's like within the realm of okay. And so Mattel sues him, right? So he sues Walking Mountain, his company, and they lose on every count, like absolutely caned on this. And the remarkable thing, and this is sort of this moment where you look and go, wow. Attorneys' costs were awarded against them for $1.8 million, and here we go. Okay, well, it's a lot of money, but okay. But for those who know the American system, you don't get attorneys' costs, right? You don't get legal fees as a matter of course. The only basis upon which you get legal fees, unless there's a statutory allowance for it, is if there's been some outrageous breach. Like in fact, the bringing of the action is so unusual and wrong that the court in its discretion awards attorney's fees against you. It's really unusual. And yet they had $1.8 million awarded against them. And anyone looking at it then and now would say this was and is a dead set loser. So why did they bring it? And the answer is sex. They were worried about sex. They've never gotten over the fact that they have to have this very, very chaste and pure Barbie object, and IP is the way in which you control that, right? You use that thing to do it, but anyone who steps outside of that, they then have problems with, and there are lots and lots of examples of that. Before we get into those examples, I just want to show you this. I highly recommend this book, David Leventhal, Bad Barbie. Mattel has finally got it. If you look through them, like it's nothing but Barbie and Ken having sex, right? Just wall to wall. And they decided actually they're not going to litigate that anymore. And so we finally got to the point where they did that. But until they did that, and that was about 2006 that he brought that out. You see all of these cases, all of these pieces of litigation that Mattel brings against people who in any way associate Barbie with sex. So reuse of Barbie as an art object, like in those examples that I showed, is okay, right? But they keep suing. They sued for the Barbie in a blender. They sued Aqua. Anyone remember this? I actually did toy with the idea of actually having a clip, but then it'd get in your head and you'd hate me forever, right? Or certainly for the rest of the day, because it's a horrible, horrible, horrible song with a Danish band, Aqua. But there's, there are, as you can see, perhaps I can't tell if you can read it. But lines like you can, life in plastic is fantastic. You can brush my hair, undress me everywhere, and so on and so forth. Mattel lost it, right? And so they sued. And the hilarious thing about this, of course they lost, right? I mean, that's not hilarious. It's like obvious because they're going to lose this one. They lost it against Judge Kaczynski. Anyway, we won't talk about Judge Kaczynski's problems. But so Judge Kaczynski rules against them in the Ninth Circuit. And then, and this is the kicker, 2 years later, I'm not joking, 2 years later, they licensed the song for an ad. Mattel licenses it. And you're like, really? Really? Okay. So somehow something happened at that point where they went, all right, we're gonna, like, we've gotten over this. But for all of that sort of period, from the late 90s through into the 2000s, they kept litigating and they kept trying to stop any kind of associations between Barbie and sex. And the way they did it was the intellectual property system. And generally speaking, unless we're talking about things like this was Barbie Benson, who was Miss Nude Canada, who had a website, and they forced that down. Karen Caviali, who had Barbie Bazaar, they said, okay, fine, you can resell Barbies, but only if you never show her in a sexual light, notwithstanding where Barbie came from in the first place. And so the fascinating sort of story out of all of this is that I should go back, sorry, one thing. The fascinating story is that they, for a long time, kept losing lots of money on their intellectual property litigation strategy. And yet the rest of their intellectual property strategy was just fine. And it's kind of like a warning story about the way in which overreach of this sort, the ability of like, we can sue and we really, really need to protect this, butts up really uncomfortably against the sorts of protections you get within the US system and perhaps less so here, and that Mattel was on a long-term kind of strategic loss around the problem of sex. And that was where for me, the detective story ran out. After I finished, this was a case that was sort of running during the time that I was working on this article. Orly Lobel has written a great book called You Don't Own Me about this particular piece of litigation, which is slightly different. It's not one that in a sense I'm actually that interested in, but it's kind of like at the moment it's the end point in the litigation about Barbie. MGA, an upstart toy company, created this line of toys called Bratz that you see there in the upper right-hand side. Big eyes, very sort of like this punk or punkish sort of aesthetic in the 2000s into the early 2010s. The guy who created that, Carter Reynolds, had 2 periods of employment at Mattel. One before he created it and one after he created it. He says that he created the Bratz line, the idea behind it, when he wasn't at Mattel. Like, and Mattel sues. They also create their My Scene line of dolls, which are somewhat similar, very different from Barbie, somewhat similar, oversized eyes, different sort of aesthetic, and of course MGA countersues. And in the end, Mattel loses again. So the sort of the most interesting thing out of all of this, if you look at Mattel's win-loss ratio in litigation, right, it never really managed, or it has never really managed to sort of make it work, right? They lost a ton of money in the litigation in relation to Bratz. It was extraordinarily expensive. They lost in relation to Walking Mountain, the Barbie, and a blender, and they've lost generally. Their intellectual property strategy on the transactional side, on the licensing side, and all that sort of stuff, working really well. And so one of the things that's sort of interesting, the lessons in relation to Barbie, and I'll close on this point, and take any questions that you like, is that sometimes companies' strategies around intellectual property are more informed by their history and the way in which they came to this point than by purely what's in their best interest, right? So Barbie is inevitably a story about sex because of the way in which she was created, but also the way in which Mattel has to make her appear demure while at the same time sort of being sexually alluring. Right? It's a very difficult line to tread. And if you're trying to use intellectual property, right, litigation particularly, to sort of work that out, then you're going to end up having a few problems. And Mattel is a really interesting case study in that. With that said, they're making plenty of money and we don't need to feel sorry about them. But it's a fascinating story. And one of those ones which has been, for me, kind of like an example of like, this is why we should look at objects and intellectual property, because they're a fantastic story. On that, thank you very much. I'll take any sort of questions you want. We have a microphone. Get that out. I have to do that, and then we'll get clear to. You able to grab that? And we should also maybe go around the offices if there is anyone left who hasn't left in a huff. Yes. Hi.
Enjoyed your speech.
Thank you.
I never really thought of Barbie and morality, but now.
There you go.
But Mattel were launching Barbie now. What would be their pitch to the market in terms of morality, be it with the 50s? What sort of, because you correctly drawn a lot of attention to intellectual property and morality, but a lot of those issues are steeped in history, aren't they?
Well, they always tried to cover it up, right? It was like, so Lily, the story about Lily only came out really a long time afterwards. So on the morality side, I mean, you can look at the sort of like the sexual morality side, you know, as sort of social conservatism. You can also look at the IP morality side. So the way in which they bought their way out of each of those problems is they covered up the Built Lily story for as long as they could. It came out and they just went, oh, well, it doesn't matter, right? Because Barbie is Barbie, right? It's Barbara Millicent Roberts. She's a teenage model. Was originally from something Falls, Wisconsin, right? So she's very chaste. So that's very easy to do. On the IP morality side, they just bought out all of the litigation with Hausner, and there was another company that actually held some of the copyrights for some of the work of Berthien, and so as a result, they did that. I don't know that the story would be any different these days. If you look at Bratz, for example, one of the criticisms around Bratz, particularly because these were dolls or are dolls for younger girls generally, the concern is that these are overtly sexualized girls, right, or overtly sexualized dolls. Look at the eye makeup, look at the pouty lips, you know, and so on. And so these are, if anything, you know, the claim was even worse representations of femininity for young women. So any manufacturer of these sorts of products is always going to come into a morality issue, and how they handle it, I don't think is really that different today than back then. None of them are going to go, oh no, we're fine with sexuality. You know, they're sort of not.
By way of comment, is the world ready for a Pauline Hanson book?
I'm going to hope. I'm going to hope not. Are there any questions in any of the other offices? We've got a couple in, let's say, Brisbane, where I used to teach. Hi, Brisbane. Anyone there want to say anything? Got a question that we can hear?
We're all good, Dan. It was very interesting. Thank you.
Great, thanks. All right. We've got Perth and I guess also Sydney. Perth is empty, so that says something. Is there Sydney there? Okay. Any other ones here? Thanks for coming. Yeah.
You might have touched on it a moment ago, but what did they do, if anything, in relation to the owners of the copyright and other rights in the Lily doll?
Yeah, so they bought them out. Right. So it never made its way to the courts. It was settled before that. So each of those ones, there were at the time. I mean, if you think about it, obviously, so there are all sorts of very difficult IP questions around, well, you know, what would the nature of the IP rights in the doll be itself? Would it be copyright? Although under the German law, maybe, because it's dealt with slightly differently in terms of the way in which they deal with sculptural and 3D forms. But it was back then. So basically, it was all that sort of thing. It was all wrapped up, and they just had a nice, neat little settlement. Bought them out, and that was the end of it. The same was true of the dyes that were used. So, you know, they bought them, and then the whole thing was sort of flushed away. Same thing happened with Lego. Exactly the same thing. You know, there was sort of like a bit of an awkward thing. It's like, oh, we'll just buy out Hillary Page. It's all good. Same sort of thing. Yeah.
Grounds. Oh, thanks. What were the grounds that they brought against Bratz? Because I mean, I assume even if their patents had been valid in the 50s, they wouldn't.
So Bratz is much newer. This is in the 2000s, right?
So what IP did they even?
Yeah, so Bratz wasn't really so much an IP issue so much as tortious interference with contractual relations, amongst a number of other things, because Carter, whatever his name is, I've forgotten his surname, Reynolds, I think it was employed at thing, and had so there was that sort of issue around whether or not he was contractually obligated to give those designs, and if they'd taken them, then in fact there was some sort of, I don't know, quantum merit claim and so on. I haven't looked at it, but it was a very complicated, very expensive, long-running dispute, which was partly factual about whether or not he did in fact create them there, because he was only a contract employee. He wasn't a long-term employee. He had like 2 periods of about 9 months each in those places. So there was a factual issue about whether or not he in fact did it. Then there was the issue about, well, is there any sort of infringement of that? It wasn't so much around mycene. It was really more, that was a counterclaim that they brought that MGA brought against Mattel. It was really more about who actually owns the profits from the Bratz line as a consequence of this this breach of either confidential information or contractual relations or whatever it might be. Yeah.
You touched on the innovative licensing strategy they adopted very early on.
Yeah.
Given your work on the future of law and your general interest in what's happening at the cutting edge, can you think of what you would say is the analogous strategy that might be adopted today? What are the emerging trends that Mattel would seize upon, or a company would seize upon?
Well, like I said at the beginning, when I'm an IP lawyer, I'm an old school kind of trademark lawyer, right? I mean, sort of used to do a little bit of copyright on the digital side, but the future is licensing. The future is trademark, right? You know, like it's just carve out as big a space as possible, carve out as strong a brand recognition or product recognition as you possibly can, and then license the hell out of it through you know, our normal sort of transactional licensing contract mechanism. So I don't know that changes, you know, and you see that, you know, Claire made the comment about gamification. And what the hell is it, right? It's the application of game methods to serious matters. I got into that through virtual worlds and online games, right? I spent a lot of time in the gaming industry. Even in that sort of virtual space, even in the very highly digital things of game design, it's still old school IP, right? It's about protecting this in terms of trademark, a little bit about copyright, but that doesn't matter really so much. It's really about sort of this standard thing that we see within that licensing kind of environment. So that is what I think the future is. You know, we've got a law degree and we force all of our students to do individual units in copyright, trademark, and patents, because that's actually what I think the future is. If you're going to be a commercial lawyer, that, you know, it was a long time ago that intellectual property passed physical plant and other assets as the major element on Fortune 500 and ASX 100 companies on their balance sheet, right? You know, the IP is much more valuable. So that's the future of law, in my view.
So what about poor old Ken? I mean, we know...
Poor old Ken.
We know that...
well, can I tell you a story about poor old Ken?
He's missing a few essential features, but yes, yeah, go.
So there's a really awful story about poor old Ken. So Ken was gay, right? That will come as a shock to all of the people who've seen the doll. But no, as a man, the son of Elliot and Ruth was gay, but he was closeted, and it was during the AIDS period, the AIDS era of the 80s. And so he was infected with HIV, he came down with AIDS, and his parents refused to believe that he was sick, and he went to South America for alternate treatment, you know, for this, and died. And so it's actually a really sad story, right? You know, and it was always this sort of this joke that Ken was Barbie's beard, or Barbie was Ken's beard, right? That he was gay, and that Barbie was Barbie as the girlfriend was just assisting him to, you know, continue to be closeted. But in fact, that was the true story about that. And lots of people, you know, at the time was like, it was hushed up and it was really a big deal. And they, you know, sort of did. But yeah, Ken was, it was a really sad story. Sorry, I didn't mean to bring the tone down, right? Otherwise, the rest of the Barbie story is hilarious, right? But
I was just thinking, he actually does a very good cameo in that Toy Story. Is it Toy Story 3?
Yeah. Well, my favourite bit I think it was the original Toy Story, is right at the end where Barbie is smiling the whole time. I don't know if you remember this in Toy Story. It's just the only thing that I really, really love about Barbie. She's smiling, going, bye, goodbye, bye now, bye. And then at the end, she's like, oh my goodness, that was exhausting, right? And she finally drops the facade, right? So Mattel has kind of worked out that they can actually allow Barbie to drop the facade, that there's an ability to play with this image that they really weren't able to do for a really long time, and they've worked it out that they can be just a little bit more permissive. The same with the David Leventhal stuff, and that Toy Story example is a good one, and Ken and Barbie do feature a little bit in that story.
On that point of Ken, that leads quite neatly into Skipper, who I think, if you look at Skipper, was less sexualized than Barbie.
She was younger, right? Skipper
Yes.
is the baby sister.
So what happened to her?
So there is no Skipper in real life, as far as I'm aware. So at that point, it was just a reaction to market forces. They wanted younger ones. Of course, Barbie, as well as Skipper and Ken, and there was another. Mitch, thank you. Yeah. All right. Why don't I just throw to you, Kelly? This is a woman who has a Barbie number 3 in her bag right now. Maybe you better come up and show, because yeah. So here is the version in a box, right? Look at this, right? So here is, I'm not going to touch it, right? So if you look there, right, for about the first, I think it was about the first 5 editions, she came in that black and white one piece, right? And here is Barbie number 3 from 1959, 3rd edition. And you want to tell about the way in which you can tell that it's a Barbie number 3?
Okay, so she's made of the same plastic as the 1 and 2, but they've changed her eyebrows. They're more rounded. They're not arched like the 1 and the 2. That's really the main change in her design. One of the ways that and this is talking about how intellectual property, even to people who don't really know what it is and think it doesn't matter, it matters, because one of the ways they date these old dolls is by her trademark markings. So the 1, 2, 3 and the 4 after this one still have Barbie TM on them, because the trademark wasn't registered at that point. And then when you get to the number 5 edition, it becomes R in a circle. So that's one of the very important markings. And when these dolls are being sold, everybody that's looking at them insists on seeing those markings, which are covered by her swimsuit. They're on her rear end back here. But they insist on seeing those and have sort of enlarged photographs so they can identify the date of the doll. So,
great story.
I think very hard to see.
Maybe there could be a private showing later, right? It seems a bit inappropriate. Thanks,
I'll
Kelly.
sit back down.
What's more expensive, the Barbie, the registered trademark, or the Barbie with the...
Oh no, the older they get, the more they're worth. The number 1 is what, 10?
About 10,000 for a decent version. There are basically no number 1s inside the original packaging. Right, so I mean, toy collectors are obsessive, and increasingly these days, if you've got something which is a collectible thing, like the Marvel the Avengers Endgame sort of stuff, there were all of these collectible things. Don't take it out of the packaging, right? Because in 50 years' time, you want it inside the packaging, so there's that. But I don't think any of the ones, maybe not even up to the 3s or 4s, are still inside the original packaging. But the original ones are about the first one is about $10,000. I think we've got about another couple of minutes, but if not,
Can I just ask the question about, I don't know if you've considered this or if this is a standard thing, but to what extent, say in the Barbie story, if say the patent system or the trademark system or the copyright system didn't exist in whichever countries, would the story be any different?
Yeah, look, I think so. I mean, certainly you wouldn't have this sort of like the litigation detective story that I've kind of outlined here. The thing that actually really attracted me to Barbie, awkward saying that, right? But the thing that attracted me to the Barbie story is that without the intellectual property system, Barbie could not exist, right? Like, so there just would not be Barbie. There would be dolls, right? We'd have dolls, there's no question. But the cultural significance of Barbie as representative of something, whether that's something you like or dislike, whether you're in agreement with it Whatever it might be, whether you have fond reminiscences of playing with Barbie as a young girl, or whether you remember like that, just would not exist, because Barbie only exists because of the purity of this particular image. I don't mean that sexually, I mean purity as an icon, right? And that exists because of the intellectual property system. So in answer to your question, in a hypothetical world where this intellectual property system didn't exist the way that it does, particularly trademark, then we wouldn't have Barbie, right?
Because trademark has provided the consistency to the name and the image.
Absolutely.
Is that right?
And it meant that Mattel knew what it had to do to police. It kept doing that, and it gave them the commercial incentive to do so. I remember like the best exam question that I ever wrote when I was in New York, and teaching trademark law to these would-be New York attorneys, was this fantastic thing of, foosball, the football table thing. And so someone had created the Barbie foosball table. They'd put the Barbie dolls on there, and of course Mattel lost it, right? And so I just like put that up there and said, discuss, as a trademark question, why is this a trademark infringement, right? Barbie wasn't written on there, it was pink, it was a Barbie pink with Barbie dolls as the foosball players. And everyone just sort of went, well, that's got to be an infringement. And you go, well, why? Because that's really fascinating. And the reason it is because Mattel was so good at delineating what Barbie meant and using the intellectual property system to define what Barbie meant. And about half of the students got it wrong. But in the end of the day, they got it. They understood what trademark and IP meant as a consequence of that.
Well, Dan, on behalf of AIPPI, thank you very much for speaking with us tonight. I think we can agree that this was one of the nights where Dan really, truly was entertaining.
One of the few nights.
And thank you very much for giving us the tools that will enable us to talk to ordinary people at parties.
Cocktail parties.
Yes, that's right, because now no longer do we have to explain that we're not actually fancy real estate agents. Now we can explain what an intellectual property lawyer is. And we always knew that IP was sexy. But now we've got the facts to back it up. So who would have known that Barbie was her own patent thicket? And who would have known that she was God's gift to litigation on such an incredibly grand scale? So thank you very much for exposing the story of Barbie, for not giving us the earworm of Aqua's Barbie girl. And I hope very much, for my part at least, that you'll come back and talk to us about handbags.
Great. I look forward to it. Thank you all very much. Thank you. Oh. I hope it was fun and interesting.